In July 1996, Dr. David Franklin walked into my office. He had been working as a medical liaison at Parke-Davis, which was the pharmaceutical division of the Warner Lambert Company. And I spent about 3.5 hours with him that day where he was educating me on what he was doing and what off-label promotion was. Was familiar with off-label prescription writing, which, as Paul has pointed out, is perfectly legal, but I'd never heard of off-label promotion. And what he described to me, the way the sales force at Parke-Davis was used and the medical liaisons, which was the position he had, they were used in purely a marketing manner to promote the drug Neurontin. Now, Neurontin had been approved by the FDA in December of 1993 as adjunctive therapy. It was an anti-seizure medication. Dave began working there in the spring of 1996. He went to training in Ann Arbor, Michigan with other sales representatives, and there they said there was a gray area where they wanted the sales reps and the medical liaisons to promote Neurontin for uses that were not approved by the FDA. And he described for me the various tactics, and that was a marketing term that a marketing firm used that we'll talk a little bit about later that Parke-Davis had hired. The tactics to promote the drug for off-label uses. They included teleconferences, dinner meetings, consultant arrangements, advisory boards, preceptorships. And with all these vehicles, the company was able to get out information about the off-label use of Neurontin. He was concerned because none of these uses were approved, so the FDA had not, the off-label use had not been studied, safety and efficacy hadn't been determined yet. The sales force was out there pushing Neurontin for various uses. And just want to read you a couple of bullets. These were some of the indications that he was asked to push Neurontin for: ALS, anxiety disorder, panic disorder, social phobia, behavior problems, dementia-related, bipolar, mania, depression, essential tremor, chronic back pain, failed back surgery syndrome, headache, migraine prophylaxis, neuropathic pain syndromes, restless leg syndromes, and dosages in excess of 1,800 milligrams. That's just a few, but there were other uses that they pushed the drug for. None of these had been studied. None of them had been approved by the FDA. When he came into my office, he had never heard of the False Claims Act. He had no idea that there was a whistleblower provision in that statute that would allow an individual to bring a case in the name of the government and potentially earn a reward if the case was successfully settled or prosecuted to a jury verdict. And in fact, I had handled some False Claim Act cases at that point in July of '96. But I had no idea as I sat there and I talked to him that this would be a viable case. Now, some of you are federal judges, some sit in state courts. The federal judges perhaps have had some experience with the False Claim Act. Many of the states, I think last count 22 or 23, have passed False Claim Act statutes. And basically, they allow a private individual to bring a case on behalf of the state or on behalf of the federal government if the federal government or state government has been defrauded. So if a company, and we're talking about pharmaceutical companies, present or cause to be presented a false claim to the government for payment, and there's the requisite scienter, they can be prosecuted. If they make a false statement that causes a false claim to be filed on the government, they can be prosecuted. So in this case, the theory that we came up with was that Medicaid, and I wasn't familiar with it at the time, but I studied the Medicaid statute, and it appeared to me that Medicaid was paying for covered outpatient drugs. Back in July of 1996, the statute defined covered outpatient drugs as FDA-approved drugs or those drugs prescribed for a medically accepted indication. Medically accepted indication was defined, as I say, as FDA-approved drug or a drug supported by a citation in one of the statutory compendia. And at that time, there were two compendium in the statute, one American Hospital Formulary Services and I think the Pharmacopoeia. Neither of them listed off-label uses or cited a citation supporting the off-label use of Neurontin. Citation could be a simple case report. A year later, the statute was amended. Drug dex was added. We'll talk a little bit more about drug dex today, but drug dex is very liberal. They list all the off-label uses. And how do they get there? The drug manufacturers send in the citations. So they can pay a doctor to write up a case report, and then they send it in, and now you have a citation in drug dex. And the manufacturing industry will argue that that citation supports the use, and they can, that now Medicaid will pay for it. So that was the theory. We filed the False Claim Act case in August of '96, a month after Dave came into the office. As you know, they're filed under seal, served on DOJ in the U.S. Attorney's Office, and then the investigation starts. The investigation, the statute gives the government, I think it's 60 days. Typically, the government will come in and ask the judge for more time. And in the case of Franklin, that went on for about 3.5 years. December '99, the judge unsealed it and wouldn't give any more extensions. The government didn't intervene. As a relator's counsel, you want the government to intervene in these cases. They didn't. My office prosecuted it for the next 4 years and 4 months. The U.S. Attorney's Office convened a grand jury, and we worked together. I didn't work with them on the criminal case, but I'm required under the statute to turn over all my deposition transcripts and all my discovery, all my documents, which I did. At one point, I ended up getting Namfuku involved. Dave Waterbury was the president of the National Association of Medicaid Fraud Control Units. As you know, those are with the AG offices. And they got together and helped me get Medicaid data so that we could show, which we did at summary judgment, we picked 10 doctors that attended these so-called CME events, which are sponsored by the drug manufacturers, and we got their prescription writing, Medicaid prescription writing before the event. At the event, they're exposed to off-label marketing message, and then we checked their prescription writing after that. We did a test case of 10 doctors. We saw their prescriptions skyrocket. That was part of our evidence on summary judgment, and we survived a summary judgment. In May of 2004, there was a global settlement of the case, a $240 million criminal fine. Susan's office was responsible for that. $152 million settlement in the civil case that I brought, the False Claim Act case, and $38 million to the State Attorney General's office, the Consumer Protection Divisions, which Dave Hart represents here today. They had that recovery. Now, that was, we have a limited number of time, so I tried to squeeze a lot in there. There was an awful lot of evidence of this off-label marketing, and we've continued to see it with other manufacturers. Just give me another minute here, Paul, because I think this is interesting. In the Franklin case, I fought for 1.5 years over a confidentiality order with the defendant. And I had all these documents that raised issues of public interest, these issues that we're going to discuss today. Judge Saris, who was the judge that sat on the Franklin case, was aware of that. And at one point, NBC, New York Times, National Public Radio, and the Boston Globe moved to intervene in the case to get access to the documents. She asked me if I wanted to disseminate them, and I said I did. And we had a litigation within a litigation over that issue. I had a First Amendment right to do that, the court found. And so these documents started to make their way into the media in 2002. And I think as a result of that, a lot of other employees of other drug companies read about this. And so I think one benefit of the Franklin case, it spawned a lot of other litigation against drug companies. And this practice of off-label promotion, promoting and using false and misleading statements to promote off-label uses of the drug was exposed. And we had the Serrano case, a $704 million settlement. Another case from Susan's office, Shearing Plow, $435 million settlement. BMS, I had one of the relators in that case, $515 million settlement. Lilly, which, out of the Pennsylvania office, $1.4 billion over the Zyprexa case. And these cases involve false and misleading promotion of off-label uses of drugs, kickbacks, in some case, pricing issues. So that's how the False Claim Act is used in these cases. Product liability law is also used. We'll talk about that a little bit later. And class actions have been used, and I can talk about that a little bit later, specifically with regard to